Over the past 75 years, more than 10,000 chemicals have entered our food supply, but the EU allows just 300 additives. At Thrive Market, we prioritize quality, banning over 1,000 ingredients found in conventional grocery stores. Our Healthy Swap scanner helps you find better versions of your pantry essentials without the junk, dyes, or fillers, and everything is delivered right to your doorstep. So shop at a grocery store that actually cares about your health at thrivemarket.com/get-started for 30% off your first order and a free $60 gift.
Welcome to Think About It with your host, Jaden Miller.
Good day, and welcome to Think About It with Jaden Miller. Thank you all for joining me again for another episode. As I always ask you guys to do, please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. I'm on all of them: Spotify, Apple Podcasts, Spreaker, Google Podcasts, Castbox, SoundCloud, iHeartRadio, and so many more. And so again, I want to thank you all for joining me on this wonderful day. Before I begin, I just want you to know that my lovely wife, Tanisha, has joined me on today, and we're going to do a little discussion in just a moment. But before I begin and introduce her to you all, I just want to begin just by acknowledging the awful event that happened in Buffalo, New York on yesterday. Today is Sunday, May 15th. And it happened on a beautiful sunny day in Buffalo, New York. And there was an individual who lived about 3 hours away from Buffalo who decided, after some time and after doing some crazy research and affiliating himself with white supremacist groups, that he would drive to Buffalo, New York, and enter a store located in a predominantly black neighborhood and kill 11 people, injuring 2 others. So we have 13 lives that have been changed because of this person's racist beliefs and his beliefs that there is some theory out there that white people are being eliminated so that people of color can take over the world, or so that Jews can, run people of color and all that. Now, it sounds really, really silly coming out of my mouth because it's really silly when we think about it, okay? But the reasons for why this person has done this and the legalities of it are going to come out real soon. But I think right now it's just good to think about the victims. One of them was a security guard at the store, and he was a recently retired Buffalo, New York police lieutenant. So he confronted this individual who had tactical weapons and tactical gear on, and actually shot him, to attempt to prevent this tragedy from going even worse. But his bullet hit an area of the gear that the person had on and didn't harm him. And so this culprit returned fire, killing this former police lieutenant. And so just another tragedy, a member of law enforcement, a former member of law enforcement killed trying to protect lives that he had done so for many years as a police officer on the Buffalo, New York Police Department. So just thought I would begin just by talking a little bit about that and reminding everyone that life is really short, and that there are people out there that could care less, that can only think about their own causes and their own idiosyncrasies, and not those of people who simply want to go to a store to purchase a few items, or those that there were some that got killed that were workers there that were trying to improve their lot in life, and again, as I mentioned, there's this Buffalo, New York former police lieutenant who gave his life. He had, again, been a police officer for many years, retired. So his service to the community was over. But yet, even still, he decided that, you know what, I can't allow this to continue. I've got to do something to stop it and, put himself between, this offender and other people, and still lost his life. So just a lot of tragedy in Buffalo, New York. Yesterday, and so I just wanted us to take a moment just to remember those people, and to remind ourselves that lives are delicate and they are valuable. So but anyway, let me introduce those that have just joined the Think About It with Jaden Miller podcast. My wife, Tanisha Miller, is joining me today. We're going to have just a little discussion about an educational topic that I've taught many, many times in classes. But she's here just to ask some questions or answer some questions. And hopefully this will be a learning experience for you all. But I'm going to talk today about the Fourth Amendment to the United States Constitution. And how it's important that we all know our rights, specifically this one. I've talked about the Fifth Amendment in the past because that's so important too. And that one just simply deals with shut up. It means that you should not talk to the police. The Fifth Amendment in conjunction with the Miranda rights. I was talking to Tanisha, my wife, earlier, and just reminding her and just saying that, the United States Supreme Court, put into place certain protections, and the Constitution has certain protections for us because of why. And I ask this question often because I want to make sure that you all understand that the reason why we have these amendments and the reason why we have the United States Constitution is because of the tyrannical rule of King George III during this country's founding. Okay, so I'm going to take you back because it's so important that we have that foundation for why we have these amendments in place. So if you remember, we talked about the Declaration of Independence, and we talked about how Thomas Jefferson wrote the Declaration of Independence to the world to outline the grievances that the colonists had against their mother country, that is King George III and Parliament. They were not being treated properly. They were not being treated fairly. And so Thomas Jefferson wanted the world to know all of these grievances. For example, when we talk about the Fourth Amendment, and I'll tell you what that is in a minute, but can you imagine, here it is, I'm a British subject, okay? Those that were living in the 13 original colonies were British subjects. Britain was, for many of them, their homeland, or that's where their parents were from, okay? And so can you imagine those from your own country coming into your home here, on this continent, okay, in these colonies, all right, just going into your home at will, searching you at will, going through your papers at will, seizing them at will, seizing you at will, seizing your children, seizing your wife, putting you in jail for no apparent reason. Okay, so imagine that. So when this country decided that enough was enough, okay, I always like to, refer to it as either a child seeking emancipation from a horrible parent, okay? Because it's really not a divorce situation. Some people like to say, the United States, leaving Great Britain was like a divorce. Well, no, because they weren't married, okay? Great Britain was the parent, the colonists were the children, okay? They had a mother country. Mom or dad, or however you like to refer to it, was not a good parent, okay? They were doing things that parents should not do. And so what is this child to do? Continue to take this abuse? Would you allow in your home, okay, if you're married or you have a significant other, for them to continuously abuse your child? No, you do something about it. And so the colonists got tired of it, okay? They got tired of being pillaged and raped and burned out and things taken from them. Enough was enough. And so they decided to leave Great Britain. Of course, there was this massive Revolutionary War that happened, but the United States became the United States because they decided to take ownership of this land for themselves, to break away from tyrannical rule. Okay. All right, so that's just a little bit of reminder of what happened. You can always go back and check out my podcast on the Declaration of Independence when I go into greater detail about it, or you can go back and check out my podcast on the Miranda ruling, because that talks a little bit about it as well. All right, so let's look at the Fourth Amendment. All right. The Fourth Amendment is a part of the Bill of Rights. Those first 10 amendments to the United States Constitution established when this country changed its constitution, changed its form of government back in 1781. All right, so the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That is the exact wording in the Fourth Amendment. All right. So now if we break that down a little bit, we see that that's in response to how they had been treated. Okay, let's look at it again. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Why do they say that? Because those things had been violated by the British government, by British troops. Okay, all right, they were coming into people's homes at will. They were seizing their papers at will and anything else that they may have had. Okay, all right. So now it goes on to say, and no warrant shall issue, because they may have had a warrant to do it. Okay, but it was not based upon probable cause. I'll explain probable cause as we go on. Supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Let's go back to that last paragraph. I'm sorry, that last phrase there. Particularly describing the place to be searched. That means specifically, okay? And the persons or things to be seized. Can you imagine back before the Revolutionary War? British troops could come in. They may have a warrant, but the warrant is not specific. It just says, we're going to arrest anyone that's in the house. How is that particular? How is that specific? Okay. It may say we're just going to seize all belongings. So what? So you can come into my house and just take anything you want. Okay. How is that fair? All right. And so the Bill of Rights, think of it. Bill of Rights, the first 10 amendments to the United States Constitution established for us our rights. And let's go through it again one more time. The right of the people to be secure. Okay, isn't that so important to us? Our security. What does Thomas Jefferson say in the Declaration of Independence? He talks about life, liberty, and the pursuit of happiness. Liberty. Okay. All right. We want to be secure in our things. All right. We want to have a life where we are free from any government agents coming in and disrupting our households. All right. Okay. So now there's a portion of the Fourth Amendment that is very, very important. And that's what we're going to focus on specifically, all right, in this episode. I think what I'm going to do is I'm going to have a series of episodes based on the Fourth Amendment, because it's not one we can talk about in 10 minutes or 30 minutes or an hour. So I'm going to break them down maybe over the course of the next 3 or 4 weeks and go over some specific cases with you that deal with the Fourth Amendment. All right. Tanisha, what do you think about that? Sound like a great idea?
It's a good plan.
All right, very good. So there is this little phrase, these couple of words here in the Fourth Amendment that are important. All right. And let me read to you these again. It says, the right of the people to be secure in their persons, houses, papers, and effects, here it comes, against unreasonable searches and seizures. See, these things can happen as long as they're reasonable. See the difference? Okay. They can't be unreasonable. All right. It goes on to say, shall not be violated, and no warrant shall issue but upon, here's this other phrase, probable cause. Okay, what does probable cause mean? Tanisha, just what do you think? What do you think probable cause means? Just looking at those two words.
That they have a good reason?
Okay, that they have a very, very good reason. Okay, a very, very good reason. Probable cause could be evidence, okay, that something or crime has occurred or something like that, okay? So very good, yes. And then it goes on to say that no warrant shall issue but upon probable cause supported by oath or affirmation. Well, that means that if you have probable cause, you want a warrant, then it has to be supported by a judge. That's what it means by oath or affirmation. A judge has to sign the warrant, okay? And the warrant has to specifically describe the place to be searched. So you can't just say, oh, I'm just going to go to somebody's house and I'm just going to search the whole house. No, it has to be specific. I am going to this address and I need to look in the master bedroom, okay, under the bed for this specific item, okay? That's what it has to state in the warrant, okay? It can't just be open, because that's not what the Fourth Amendment says. It says that it protects you against unreasonable searches and seizures. That means they have to be reasonable, okay? And it's unreasonable for you to have a warrant that says, oh, I just want to go into somebody's house and search the whole house. So you're going to go into the little baby's room and go through the little baby's diaper bag. That's unreasonable, okay? All right, unless you have probable cause, a very, very good reason, and a judge signs it, okay? Also, it talks about describing the place to be searched and the persons or things to be seized. That means people too, because you can be seized, all right? Wouldn't it be unfair, like it was back before the Revolutionary War, for police agents, government agents to come and just take you away? See, that's what Thomas Jefferson complained about too in his grievances in the Declaration of Independence. People would be seized, taken clearly across the ocean back to Great Britain for a trial, or they would be taken back to Great Britain and put in a cell and not have a trial. Okay? How is that fair? Their parents, their relatives would not know where they were. Okay? How is that fair? How is that good government? Okay, so our Constitution guarantees you that if you're going to be seized by government agents, they have to have a warrant, and it has to specifically state who they're looking for or what they're looking for or who they're seizing. Okay, very, very important. All right, so now we've looked at the Fourth Amendment. Let's ask ourselves a couple of questions. Tanisha, you would agree that the Fourth Amendment was written back in the 1700s, correct?
Yeah.
Okay, so now we're in the year 2022. Mm-hmm. Would you say that a lot has changed from 1781 to the year 2022?
Yes, definitely.
Absolutely it has, okay? So the thing about the Fourth Amendment, it's really, really great, and it was really, really perfect, written for the time. But we know that in the United States that we as a people have grown socially, okay? Well, back when the Fourth Amendment was written, okay, it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. That didn't mean all people, okay? It certainly didn't mean African Americans who were slaves. They had homes, okay, that they lived in, or cabins or what have you, but this did not apply to them, okay? It certainly didn't apply to the American Indians that were here, okay? And guess what? All right, it really didn't apply to women because women didn't have rights, okay? All right, so this really specifically dealt with men at the time, all right? So, of course, we know that, well, back in 1865, the Civil War was over, so now black people are freed, okay? We know that women, in the early 1900s got the right to vote. So now they've made some definite improvements in terms of their citizenship, their class. They're not second-class citizens anymore. They can vote just like men, all right? Well, because things change, the Fourth Amendment has had to change as well, okay? All right, so there are some things that we have now that we didn't have in the 1700s. For example, it says the right of the people to be secure in their persons, houses, papers, and effects. What about cars? Well, guess what? We didn't have cars back in the 1700s. So how does the Fourth Amendment apply to that? Okay, that's a question that we have to ask, okay? Well, what if you're not being seized, okay? But police believe that you may have something on you, okay? But because they need to be protected, okay, they need to do a search of you. This does not provide for that, okay? So we've had to, or the United States Supreme Court over the years has had to make some decisions about the Fourth Amendment, all right? And so, as I mentioned, I stated that I was going to talk to you over the course of the next few weeks about some issues that go along with the Fourth Amendment, all right? Well, there are what we call some exceptions to the Fourth Amendment warrant requirement, okay? Well, again, as I mentioned, the Fourth Amendment was written in the 1700s, but times have changed, okay? All right, and so the Supreme Court has said that there are some exceptions to the Fourth Amendment warrant requirement. Why? Because even though people need to be safe and secure, well, on the other side, the government has to be able to do its job more effectively, okay? And you can't do it most effectively if you see something happen, but you can't do anything about it because you've got to get a warrant. Okay, well, guess what? Well, if someone's committing a crime or they have evidence and you've got to go all the way back to a court to get a warrant, then guess what happens to that person? They leave. They get rid of the evidence. Okay, so now that person has committed a crime and gotten away with it because you didn't have time to go back to get a warrant. Okay, again, that's why I say that the Fourth Amendment has had to grow as the nation has grown. All right, and so I want to talk to you all about a few exceptions to the warrant requirement. The first one I'm going to talk about is Terry versus Ohio. All right, I want to talk about Terry versus Ohio because Terry versus Ohio deals with this whole matter of search and seizure, okay? And it's a really, really important case, all right? Because, again, it deals with what do police officers do when they don't have probable cause to arrest somebody or probable cause to seize someone. You all heard Tanisha say that she believes probable cause means what again, Tanisha?
I was just saying they have to have a good reason.
They have to have a good reason. Well, what if the police don't have a good reason? Mm-hmm. But yet they believe that something may happen, okay? So in Terry versus Ohio, this is a case that happened back in 1968, okay? Or at least that was when the Supreme Court ruled on it, all right? So I'll just give you a couple of facts of the case. You had Terry. He was the plaintiff in this case, and two other men were observed by a plainclothes policeman in what the officer believed to be casing a job or a stick up. I'll give you some more information about it in a minute. The officer stopped and frisked the three men and found weapons on two of them. Terry was convicted of carrying a concealed weapon and sentenced to 3 years in jail. Okay, so now, was the search and seizure of Terry and the other men in violation of the Fourth Amendment? Well, what does the Fourth Amendment say again? Okay, it says the right of the people to be secure in their persons. It goes on to say that a warrant shall issue but upon probable cause. They didn't have a warrant. That officer didn't have a warrant, right? So then if he didn't have a warrant, how could he search and seize them? The Fourth Amendment specifically says that you must have that. He did not have that. Okay, so now let's talk about this for a few minutes because as you all know, I am a former law enforcement officer. Okay, so now we have police officers that have worked the job a lot of years. Okay, in my instance, I had this hunch or this belief when I knew somebody was about to do something wrong. Here, I'll give you an example. So me and my partner were checking out, I believe it might have been a Church's Chicken place or something like that, okay? All right? And there was a guy that was acting very suspiciously, all right, on the outside of the store, okay, the restaurant, okay, or the fast food joint. I guess chicken is fast food now, right, Tanisha?
Yes.
All right. I remember chicken didn't used to be fast food. Chicken was like that meal that you would only serve on Sundays, right?
Yeah.
You can have chicken every day now, can't you? You can have. Go ahead.
Perfected their process.
You can have
now.
chicken 2 or 3 times a day if you want to. All right. Well, so now as me and my partner are observing this person, he's acting suspiciously. Now, okay, for those of you that are untrained, you might be asking, well, how was he acting suspiciously? I mean, what was he doing? Well, he was looking in, and then he would look away. He would look around to see if anybody was watching him, you know. And so again, if you're not a trained law enforcement officer, that may not mean much to you. But for us, it meant a lot, because those are the signs that someone is casing a place. They're looking out to see who's around so that they can go in and, you know, do whatever it is that they want to do. Armed robbery, stick up the place, whatever you want to call it, okay? So those are some of the signs that we see, all right? So then this person was doing that. Now, of course, Terry versus Ohio had already been decided before me and my partner, even got on the police department, okay? This case was from 1968. But anyway, so what we were able to do is we got out of our car. Now, again, the question is, do you have a warrant? We didn't have a warrant, okay? All right. The person is acting suspicious, but do you have a probable cause to seize them? No, we do not. Okay. Well, what is it about this person? Well, because we're trained police officers, we know that these are telltale signs that someone is doing something or about to do something they should not do. So the question is, do we just sit back and let a crime be committed and then go and try to stop it? How would you feel about that? So check this out, Tanisha. So me and my partner, we know that a crime is about to be committed because based upon our experience, we know that this person probably has a gun. He's watching out. There's a car right there. Maybe somebody's in the car. The car is running. They want to run in real quick, conduct an armed robbery and then run back out. So let's say we do that. We just wait, let him run in. What if he shoots the clerk? Mm-hmm. Now, we're sitting there and we could have done something about it. Mm-hmm. Okay? So the question is, do we violate the Fourth Amendment, or do we say, hey, we don't have a warrant? Mm-hmm. We can't, there's no probable cause that he's going to do it. He's just a citizen standing outside of a fried chicken place, looking around. Is that against the law? Okay? Well, the answer to those are no. Okay? But the Supreme Court said, but wait a minute. What if he does go in and shoot somebody? Mm-hmm. And the police are right there. And the Fourth Amendment doesn't give them the authority to do anything. How is that right? Mm-hmm. How is that a good thing? So in this case, the Supreme Court said, something's not good here. We need to make some changes. Let me read to you what the Supreme Court said. It was an 8-1 decision. The court held that the search undertaken by the officer was reasonable under the Fourth Amendment and that the weapon seized could be introduced into evidence against Terry. Listen to this. Attempting to focus narrowly on the facts of this particular case, the court found that the officer acted on more than a hunch and that a reasonably prudent man would have been warranted in believing Terry was armed and thus presented a threat to the officer's safety while he was investigating his suspicious behavior. The court found that the searches undertaken were limited in scope and designed to protect the officer's safety incident to the investigation. We need to go back and think about the 1960s. Tanisha, you remember the 1960s? What was going on? What was going on in the 1960s? Didn't we have a civil rights movement?
Yes.
Wasn't there a lot of violence associated with that?
Yes.
Okay. You will recall that during the 1960s, there was lots of violence against the police. Mm-hmm. Okay. Didn't we have a Vietnam War going on? Mm-hmm. Okay. We had, in 1968, we had a Democratic National Convention where there was a lot of violence by the police and against the police. Do you know who got killed in April of 1968? Dr. Martin Luther King, right? And then shortly thereafter, running for president, Robert F. Kennedy was shot and killed. Mm-hmm. So we had so much violence going on in the country during that time, okay? So the court said, we we have to find a way to protect our police officers and give them the tools that they need in order to prevent themselves from being harmed, but also to prevent someone from being hurt because the police don't have those tools. So again, in this case, what if that police officer just sat back and said, you know, I can't do anything? They go in, and by the way, their intention was to go in and rob the place. Okay? So their intention was to go in and rob the place. But what if he just sat back and says, well, you know what, I'm not going to do anything. I can't do anything. I mean, I don't have a warrant. And then they go in and they rob the place. They shoot someone. So as a society, what would we like better? Would we like for the police to have the tools that they need in order to be effective, or for them to sit back and let ugly things happen? What do you think?
I mean, that's hard because I do want to be protected. So if a police officer with his training and experience thinks that something is about to happen, I'd like him to be able to use that and protect me and others. And at the same time, I'm concerned about things like racial profiling or whatever, or you feel that somebody's about to do something, but you don't maybe realize that that has to do with your own bias.
Right.
You know, against maybe people who look like that or people of a certain race or whatever. So,
well, that's a very, very good point. Absolutely. So in this case, what the Supreme Court established was a legal standard of proof. That's different from probable cause. Remember, probable cause has to be what? The legal standard for arrest and warrants, okay? But it has to be based on something that, you know, would lead a reasonable person to believe that, yes, this person probably did it. That's probable cause. But see, they established this thing called reasonable suspicion. Reasonable suspicion is a legal standard in the United States that is less than probable cause, okay? So less than means, what would a reasonable person say if the police told them, well, a crime has not happened, but I believe that it could, okay? So remember, you don't have probable cause, but you have something else. You have this training and something more than just a hunch. You have this, you know, I've been a police officer 20 years and this doesn't seem right. So for the average citizen, he's just standing outside of a store. For a police officer, he's acting very suspiciously, okay? So they established reasonable suspicion. What a police officer has to do, or has to be able to do with the standard of reasonable suspicion, is to clearly articulate why you did something. Okay, so here, let's go back to Terry versus Ohio. We have this police officer that sees 3 individuals outside of a store, casing it. Okay, so that's based upon his years of experience. He reasonably believes that they may be getting ready to commit an armed robbery. Okay, all right, well, he needs to approach these individuals. Okay, because it's one thing to know or believe that they're going to do it. Well, what are you going to do about it? Okay, that's the next step. Remember, the Fourth Amendment says you need to have a warrant in order to seize someone. Okay, well, he doesn't necessarily want to seize them. He wants to see what they're doing, see if they have anything on them that may they may be able to use in order to commit this crime. Okay, but again, the Fourth Amendment doesn't say that. It says it has to be probable cause supported by oath or affirmation, right? And clearly, specifically state who you're seizing and what you're seizing. Well, he doesn't know that. He doesn't know if they have guns. He believes that they have guns. Okay, knowing probable cause, believing reasonable suspicion. 2 different things, okay? So now he approaches them, all right? And for his own protection. Remember, 1960s, lots of violence against the police. He has to be able to protect himself, okay? How does he do that? Remember, the Fourth Amendment says, let's go back to it. It says, hold on, let me go back to it. I've got it on my screen. It says the right of the people to be secure in their persons. In their persons. Persons means your clothing, okay? All right. Well, where do people have guns? In their clothing, right? Okay. So now the Fourth Amendment says the right of the people to be secure in their persons against unreasonable searches and seizures. The Supreme Court now says, well, you know what? That's not unreasonable. That's reasonable, okay? The standard was not there in the 1700s of reasonable suspicion. Now the Supreme Court in this decision gives police officers this new legal standard of reasonable suspicion. So now the officer can approach Terry and the other two defendants. He can have them to put their hands on the wall. Okay, we see that in police shows, put your hands up, so that he can do a search of them. Okay, a search. Remember, the Fourth Amendment says you have to have a warrant. No warrant shall issue but upon probable cause supported by oath or affirmation. Well, does he have a warrant?
No.
He does not. Okay, according to the Fourth Amendment by itself, he can't just walk up to people and search them. But what if he's in danger? What if people inside the store are in danger? So what happens is we have what's called exceptions to the warrant requirement. Individuals' safety, your safety always trumps someone else's when it comes to them committing a crime. Okay, so for example, in this case, all right, their Fourth Amendment rights were not taken away from them. They were not violated, because guess what? You have a right to be safe and secure, okay, against someone else's right, okay, to do something wrong or to be protected from doing something that they know is illegal. I'll explain it a little better. Okay, so in this case, Terry feels that I'm a police officer. I'm by myself. There are three individuals. I believe they've got guns. I believe they're going to rob this place. So what if I walk up on them and they start shooting? Okay, I have no protection. So as a police officer, I have the authority. I can pull out my gun and I can point it at them and tell them, you three, I need you all to face the wall, put your hands up. He can holster his gun and then he can pat them down. All right. The courts have established there's a difference between searching someone and patting someone down. And this all goes back to Terry versus Ohio. So the warrant requirement, the Fourth Amendment in this case, was not totally taken away. There was a new standard issue and then a procedure for police to use. Okay. So let me explain it to you. What the officer did was he patted down the outer clothing of these individuals, okay, to determine if they had weapons. How can you determine that? How can you determine if someone has a weapon if you're patting them down? By what?
You're just going to feel it.
By feeling, okay? So a reasonable person, right? There's this reasonable standard. If they're patting someone down and feel a hard metal object, a reasonable person would believe that that's probably a handgun, right? Okay, all right. So then we've patted them down. We've not done a search of them. A search is if we go into pockets or go into their clothing, but we're just patting it down to determine whether or not they do have something that they shouldn't have. All right. So we haven't violated the Fourth Amendment. Okay. The Fourth Amendment, the reasonable standard was in addition to the Fourth Amendment. So your rights are still protected. The police officers are not searching inside of your clothing and violating your right to the Fourth Amendment. They're doing something to protect themselves. So your rights, okay, are not more so than the police, and the police don't have rights more so than you, but we still have to protect those people that protect us. So they're given the opportunity to pat you down. Now, if they feel something that's clearly articulable, meaning they can say, I felt a metal object, it appeared to be a handgun, that's enough, okay? Then they can seize it, okay? So that's when the warrant requirement is tossed aside, okay? You don't need a warrant if you feel a hard metal object. Remember, we got to talk about reasonableness now. So what if they had to go get a warrant? So he feels somebody with what he believes is a gun, and then he says, oops, that feels like a gun. Okay, but I can't take it. So now I've got to go and get a warrant to come back. Are you going to be there? A criminal's not going to be there. He's going to be like, okay, go get your warrant. I'm out of here. Yeah. Okay. Now you can always say, well, you can call other police units and have them to wait. Well, see, then you get into another issue, because then this person isn't free to go. Okay. Right. Remember, we still have constitutional rights. Now this person isn't free to go. Are they arrested or not? So we get into a whole nother legal thing. Okay. So that's why the reasonable standard is there. If the police officer feels it's a weapon, then he can seize it without a warrant, okay? Because remember, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches. Okay. But this one's not unreasonable.
Right.
All right. So now once he takes the weapon, okay, then he has to determine whether you have that weapon lawfully. Okay. Well, this is 1968. You didn't have weapons on you concealed lawfully, okay? Especially I think that was in Ohio. Yeah, Terry versus Ohio. So I think that was in either Cincinnati or Cleveland. But anyway, the officer seizes the weapon, and 2 of the 3 individuals had guns. So his hunch was right. They were going to go in and rob the place. All right. So now he seizes the weapons from both of them. All right. He goes into their clothing. Now he has the authority to seize the weapons and place them under arrest. They were convicted. Okay. So what Terry established was that the police don't have to have a warrant, okay, to conduct a pat down search. People get confused between what a search is. So if I pat you down, that is different from searching you. Okay, searching you is going through your things, the right of the people to be secure in their persons. All right. So if I were just to roll up on you in my police car and then pull down your pants and go into your underwear, that's unreasonable. Unless I have probable cause. But if I don't have probable cause, but I have a reasonable suspicion and I can do a protective pat down on your outer clothing, then if I find something, okay, then I can seize that and seize you, okay? Now, going a step further, all right, when we talk about the 4th Amendment, all right, once you've been seized, once you're under arrest, then a more thorough search can be done without a warrant, okay? Because if I'm going to put you in jail, I can't put you in jail and you have all kinds of other, contraband on you. So now the police can go into your underwear, go into your clothing, because again, remember, it's not unreasonable. It's that unreasonable and reasonable standard that we have to really, really understand. And it has to be based upon clearly articulable facts, all right? Clearly articulable facts. The police officer has to clearly state the reason why he did so. So let's go back. I'm going to do this for you. All right. You ready, Tanisha? All right. You've been so good. All right. So here. So I'm going to go back to my situation with the chicken. So me and my partner see this guy. All right. And so we have this belief, not probable cause, because if we had probable cause, we just go get him.
Right.
But we have a reasonable belief. So we watch. And then we determine, you know what, we need to go do something. All right. So we go and we stop him. Okay. It's called Terry versus Ohio, stop and frisk. Pat down is another name for it, okay? Patting someone down or frisking them. Frisking and patting down is not a search. I want to make sure that my listening audience understands that. Search is much different than patting someone down and frisking them, okay? All right, frisking is feeling the outer. Searching is going in, pulling things out, okay? There's the difference there. So we went up to him. We had him to put his hands on the wall, and we conducted a Terry pat down search. We felt along his arms, okay, along his side, down his legs, down his back, because that's where people hide weapons. And we found that, yes, he had an unlawful weapon, okay? We seized the weapon, all right, and placed him under arrest. Why? Because you cannot have an illegal weapon, all right? We didn't place him under arrest because we thought he was going to go in and rob the place. We don't have any probable cause. He didn't do that. Okay, but he did have something that he could have used to do that. That thing that he had was unlawful, illegal. Okay, so we seized that. All right, now once we've seized that and he's under arrest, that then gives us the right to do a search. Remember, we did a pat down, a frisk. That's different than a search. Once he's under arrest, he's in our custody. Okay, and for our protection and in order to determine if there's anything else that he has on himself, okay, that's illegal. Now we can search his pockets. Now we can go into his coat and search his coat pockets. If he had a bag with him, now we can go into his bag to determine whether or not he has any other weapons or if he has any illegal contraband. All right. Also, we have to inventory his property. All right. And so what we have to do is make sure that we have a listing of all of the things that we seized. Okay. And so the courts have found that when someone is under arrest, okay, and then you need to inventory their belongings, then you do not need a warrant in order to do so. All right. So here we have Terry versus Ohio. We have this one case, all right, and the Supreme Court ruled that in this particular case that the police officer was definitely following a reasonable suspicion, and that it was understood that, you know what, this was a good outcome, okay, because no one got hurt. The police officer didn't get hurt. The individuals in the store didn't get hurt. So that was really, really important in this case. And it's been established since 1968. All right. So I wanted to talk about Terry versus Ohio. As I mentioned, the Fourth Amendment is just this broad, amendment. And there's so much to it. So I'm going to wrap up today, talking about Terry versus Ohio. Tanisha, was there anything that you learned today from this particular case?
Oh, definitely. The difference between patting down and actually searching, and what reasonable suspicion and probable cause and all of that are.
Yes, absolutely. And the fact is that, again, police officers have to be able to clearly articulate why they do certain things, okay? So it's not like, oh, okay, well, I just felt like. No, it's got to be more than that. I'm a police officer, okay? I've been a police officer for 25 years. And during that 25 years, I've made 250 arrests for armed robbery. In this particular case, I was observing several individuals, okay? They were looking inside the store and then looking around, okay? I saw a vehicle with an occupant in it, That person was looking rather suspiciously to me as well, okay? These people kept looking into the store, seeing if anyone was in, and looking back and looking at the person in the car. That seemed really suspicious to us as police officers. Those are telltale signs that someone may be about to commit a crime, okay? See, that's clearly articulating, okay? So we decided, okay, in the interest of public safety, all right, to have a discussion with these individuals. Well, by having a discussion, we have to make sure that we protect ourselves, because these people could pull weapons and shoot us. And so we have them to put their hands on the wall. We conduct a Terry protective pat down search, and we found that they had metal objects, in their back, and the other one had them in his pants leg, okay? Well, once we determined that those were probably handguns, we seized them, okay? And then placed the suspects under arrest. See? Clearly articulating what happened. Courts will say that is reasonable, okay? That is a reasonable Terry versus Ohio protective pat down. All right, so listen, guys, please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. We will continue to talk about the Fourth Amendment and the exceptions to the Fourth Amendment requirement the next time. Hopefully, Tanisha will come back and join us and, share with us some of her thoughts on these different exceptions to the warrant requirement. There are some that are really, really great. And so Terry versus Ohio is one of those, but I've got some other ones that deal with plain view, that deal with consent. What happens if the police knock on your door, okay, and you let them in, okay? Well, what if they see something, okay? Well, do you have to let the police into your house? So those are some things that we'll come up with. What about automobiles, okay? Well, remember, the Fourth Amendment was written before there was automobiles, okay? So are there exceptions to the Fourth Amendment requirement when it comes to automobiles, okay? What about things that are in plain view, okay? What about kids at school? The kids at school have Fourth Amendment rights, okay? All of those things we'll talk about in the upcoming episodes. Thank you guys again for joining me. Oh, here, let me put in a plug, okay, for these guys. The Man Space Podcast. I was on them on their show about a month ago. It was really, really great. That is Russ and Les, and they are fantastic. You can find them on the manspacepodcast.com, or you can find their podcast, the Man Space Podcast, on any of the on your favorite podcast platforms as well. So I wanted to give a plug out for those guys. But again, thank you all for joining us. Not just me, it's us. Tanisha's here too. And we will see you on the next episode. Have a great day.
Bye, everyone. Thank you for listening to Think About It with Jaden Miller. Don't forget to like and subscribe to his YouTube channel, and like and follow on your favorite podcast platform.